Donald Trump is lying in court and to the public. What's new? Welcome to Law and Society. Please subscribe. And I want to talk about this specifically because Donald Trump's lawyers are misquoting Trump v. United States, which is the case, the Supreme Court opinion that gives presidents certain level of immunity. Well, it doesn't seem like Donald's lawyers are very happy about the extent to which the immunity has been extended. They wanted more. So what they first did was they tried to say in front of Judge Chutkan that the Supreme Court had held that communications between Donald Trump and Vice President Pence would be immune. But what the Supreme Court actually said was that conversations between the vice president and Donald Trump at the time when vice president was performing his function as president of the Senate in the context of the Electoral College votes, that does not fall into the category of an official conduct because it is president of the Senate that is discussing electoral votes, and Donald Trump doesn't have any sort of immunity. Speech or debate clause does not immunize Pence from testifying, and there is no immunity because Donald Trump is not talking to somebody of the executive branch and is not talking about something that is of part of his core duties or even the outer perimeters of his duties. So Judge Chutkan caught that lie right away and said that no, the Supreme Court said that such an instance is presumptively immune, saying on its face it may seem like a communication between president and vice president would be immune because the president is talking about official duties. But when it is talked that when it comes out in evidence that what they talked about was not within even the outer perimeters of a sitting president's official duties, then they become unofficial acts and they are criminally liable for those acts. So Judge Chutkan clarified that right away, but that didn't stop Lauro from trying to bend the Supreme Court's ruling. Then Alina Hubba went on national TV and said that any acts he committed in the White House while in the Oval are immune. No, that's not what the Supreme Court said. The Supreme Court gave 3 zones. One of it was absolute liability for core official conduct. Then there is immunity, absolute immunity from official conduct. Second, you get a presumptive immunity from conduct that has that may or may not be immune, and that is what the district court has been remanded. The case has been remanded to the district court to do. So Judge Chutkan pointed that out really quickly, but there's nobody in the media who pushed back against Hubba saying that he's immune. No, he's not immune. There's a presumption of immunity for certain acts, like Laura brings up about the vice president, that are presumptively immune. And the immunity doctrine that Trump v. United States came up with will be applied to Donald Trump's case in the immunity hearing. So with that, I want to read you two small parts of the Trump v. United States opinion. Here we go. This is on page 15 of the slip opinion of the Supreme Court opinion, which is now available on the Supreme Court website. I have provided the link for this case in the description box. If you go and check page 15. It is towards the middle of page 15 of the slip opinion. The justifying purposes of the immunity we recognized in Fitzgerald and the one we recognize today are not that the president must be immune because he is the president. Mind you, this is what Alina Hubba and Lauro are arguing or trying to argue and presenting to the public. Rather, and this is important, rather, they are to ensure that the president can undertake his constitutionally designated functions effectively, free from undue pressures or distortions. It is the nature of the function performed, not the identity of the actor who performs it, that informs our immunity analysis. So I'll read the last part again. It is the nature of the function performed, not the identity of the actor who performs it, that informs our immunity analysis. And then, so we know that it is the nature of the function performed. What was he talking about? That's what the immunity attaches to. If he's talking about the Electoral College and pressuring Mike Pence to change the Electoral College count, that is not within the president's powers, because that is vested to Congress and the various states. President has no authority in election matters. The immunity we have recognized extends to the outer perimeter of president's official responsibilities, covering actions so long as they are not manifestly or palpably beyond his authority. So electioneering is manifestly and palpably beyond his capacity, beyond his authority, because the Constitution vests that power upon Congress and the states. So we will see a lot of misinformation and disinformation coming out. I wanted to make this quick video, to let you know that they are trying to bend past its reach, Trump v. United States, and they tried to do that in court. They tried to do that in court. So there's nothing stopping them from doing that in public debates and bringing up this thing of immunity, this from now until November, and misquoting in bad faith what the Supreme Court ruled. They're not happy with the ruling they got. They're not happy because even under this ruling, Donald Trump is liable for its unofficial conduct. And the indictment, the superseding indictment, points to only private acts and unofficial acts, and acts over which Donald Trump did not have any constitutional authority, or he was not in, it wasn't even the outer perimeter of his authority. It was not palpably in his authority. It was not manifestly in his authority. It was nowhere in his authority to deal with elections. And neither does this prosecution do anything to jeopardize the president's constitutionally designated functions free from undue pressures or distortions. There's nothing in the actions and the indictments that have brought up that would in any way get in the way of the sitting president's any duties, whether it be core or outer perimeters. So that's what the superseding indictment does. And by that, it makes the job easier for Judge Chutkan and the process of the immunity hearing, which we're going to see the opening brief on the 26th of September. So from now until the 26th of September, there's going to be a lot of trading of information. There's going to be disclosures of evidence, and there's going to be a reply saying what evidence of the immunity was not included. Giving up exculpatory evidence, which is required. It's called the Brady rule, that prosecution has to give up to the defense any evidence that would exonerate or help the defendant's case. And all of that, I'm sure that the government is more than happy to help with. And we're seeing here Donald Trump's last-ditch efforts to not even have this hearing, and that has not succeeded. So we're going to very likely see a hearing on the matter of immunity before the election, because Judge Chutkan will not take the election into consideration when assessing pre-trial procedures. We're not talking about the trial at this time. We're talking about the pretrial procedures and the immunity hearing. With that said, thank you very much. Please like and subscribe, and I'll talk to you soon.